So in this case, Matthews and Winslow Constructors, a female employee was working as a labourer for a construction company. She'd been working there for 2 years, and throughout her employment she was subject to quite extensive and repeated abuse, bullying and sexual harassment from her colleagues. There were a number of cases that the court looked at, which included her being shown pornographic material, being called sexual names, repeated questioning over her sexual life. It kind of ended, well, the employment ended eventually when one of her colleagues threatened her that he was going to follow her home and rape her. Following the comment, the female employee tried to contact HR to make a formal complaint, which was met with a comment that she should come over to his place and they'll have a drink and talk about it. She resigned because she couldn't continue to be put up with the conduct. What was interesting was she wasn't able to make complaints to any of her other managers in the business because they were actually the ones that were abusing and harassing. So she resigned from her employment and visited a number of doctors, psychologists and psychiatrists who found that she was suffering from bipolar, anxiety and depression. It was found that she was unable to ever be able to work again. During the proceedings, Winslow Constructors originally tried to claim that it wasn't responsible for the actions, or if it was, that it was only contributorily negligent. However, on the 5th day of the hearing, the company eventually conceded that they were negligent, and the judge was just required to consider what damages the employee should be awarded.
It's interesting that one of the other tactics that was taken on behalf of the defendants was to take footage of the employee walking around, sort of covert footage, and to put forward that her psychiatric injuries were not as described by the doctors because she looked happy in the video, which seems a bizarre tactic for the court, because obviously the court's only going to have regard, as was said in this decision, to the actual expert evidence, not what someone might say about somebody's video footage.
Yeah, I think it's a really sad case. Obviously, given that she was awarded over 1.3 million, there's really significant damage for this woman ongoing, and there's been huge failures in the workplace. I mean, it's the sort of workplace you can imagine that they haven't ever done any sort of training or sharing of information as to what is actually required. I mean, the construction industry generally can get quite a bad rap, and I think it's down to companies like this and other serious cases that we've seen where people are discriminated against for various different reasons. In this case, I think, as you mentioned, she went to her manager, or couldn't go to her manager because they are in fact one of the people that was bullying her and harassing her. She tried to go to the person that she thought was HR, and really offering to have a drink with someone in these circumstances is highly inappropriate, and so there was nothing in place, no one she could turn to, no sort of system set up formally, which, you know, really every company should have, particularly now that we have the bullying jurisdiction, as well as these type of breach of duty of care, sexual harassment cases, that she should have known where she could go, what she could do, and how she could get help without having to resign.
And I think it also does emphasise again the importance of that role of human resources. I mean, if it is a special position, and if you've got the title of human resources, or the like, that particular position, you've got an obligation to act in accordance with a proper process once knowledge comes to you in relation to a complaint. And the courts and the Fair Work Commission and, you know, equal opportunity tribunals, etc., throughout Australia always react very badly when you have someone in a human resources role who does not respond appropriately when a complaint or inquiry is made.